સિક્સ બીજીપીસી અને સુખડવાલા વકીલ સીપીટી રાણા તમે રાણા તમે રાણા સાથે શું
આમાં અત્યારે થવાના છે કોઈ
નથી સર રાણા
ચાર કે
નંબર 7 વકીલ સી એને બગાસિયા નટવરભાઈ વિઠ્ઠલભાઈ રામોલિયા
બોલો આમાં એક જ વ્યવહાર છે ફરિયાદી છે અને આરોપી છે અલગ અલગ ચેકો હતા એટલે આ કેસમાં જે કોષ્ટક છે
એક જ કમ્પ્લેન્ટ સુધી પડી છે એક જ કમ્પ્લેન્ટ સુધી પડી છે પાસ તો એક જ કોર્ટમાં છે ને
એક 6 નંબરની છે ને એ જ અલગ છે
ચેક કર
1 થી 5 છે ને સાહેબ
ચેક
એમાં
કર લો આ બુદુલિયા મેડમ મારી એક જ અત્યારે એની એ જ રીતની હોય તો જો ઓર્ડર કર
પેલામાં
શ્રી ત્રિપાઠી સાહેબમાં થશે
જી સર
સ્ટેજ નંબર 9 પીસી જીએમ પાટીલ બીજીપીસી અને સુખડવાલા સ્ટેજ નંબર 9
8 ઓર્ડર માટે કરાવો નંબર તેનું બરાબર મૂટ વાળું છે ઓર્ડર માટે આમાં કઈ કહેવાનું નથી 6 તારીખ લો છો
સ્ટેજ નંબર 10 પીસી એસટી ગુગે
બોલો
સદર ગુનાની ફરિયાદ સાહેબ 17 બનાવ સાહેબ 17/9/2025 નો ફરિયાદ સાહેબ નોંધાઈ છે 18 તારીખ 24 કલાક સાહેબ સદર ફરિયાદ નોંધી છે સાહેબ ફરિયાદ વાંચવામાં આવે સાહેબ એનો પેરા નંબર 2 છે એમાં ફરિયાદી પોતે જણાવેલ છે કે મેં ફોન કરીને જણાવેલ છે મારા ભાઈ પાસેથી મોબાઈલ ગેમ લઈ ગયેલ છે જેથી તેને મને જણાવેલ કે મારા ભાઈને મેં મોબાઈલ વેચેલ તે પૈસા આપતો ના હોય જેથી હું મોબાઈલ લઈ ગયેલો એટલે મારા માલિકનો મોબાઈલ હતો એ મેં વેચેલો હતો સાહેબ એ મોબાઈલના પૈસા ના આપતા મોબાઈલ લેવા માટે મોબાઈલ લઈ લીધો હતો એ બાબતે સાહેબ ઝઘડો થયો એને મને બોલાવ્યો સરદાર બ્રિજના નીચે બતાવે જ છે સાહેબ એમાં કે મેં એને કહેલ કે જણાવેલ કે સારા દરવાજા બ્રિજ નીચે છું અને થોડી વારમાં રોહિત સારા દરવાજા બ્રિજ નીચે આવે એ સાહેબ આરોપી બ્રિજ નીચે ગયો પૈસા લેવા માટે સાહેબ પૈસા ના આપ્યા અને ફરિયાદી પોતે એની ફરિયાદમાં બી જણાવેલ છે કે 5000 આપીને લઈ લે એવું અમે જણાવેલ છે
છૂટીને પછી તરત બીજો ગુનો કર્યો છે
સાહેબ હમણાં જ છૂટેલા છે
છૂટીને તરત બીજો ગુનો કર્યો છે ને
20 દિવસ જેવું છે
હા ચાલો બોલો શું કરવું છે
સાહેબ આપવામાં આવે સાહેબ જામીન કારણ કે સાહેબ અમારી કોઈ ભૂલ નથી સાહેબ ફરિયાદી પોતે જણાવે છે ડિસ્ચાર્જ બી છે
તો
સાહેબ
તમારે બધી દલીલ અલંકારિક ભાષામાં લખી નાખી
ફરિયાદી સાહેબ પોતે બી જણાવેલ છે
અરે ભાઈ ફરિયાદી ને બધાની વાત જવા દો છૂટીને હજી તો તમે એકમાંથી જામીનમાં છૂટતા છો
સાહેબ અમારી કોઈ ભૂલ જ નથી સાહેબ અમારે મોબાઈલ વેચેલો હતો સાહેબ એ મોબાઈલના પૈસા લેવા માટે સાહેબ એને બોલાવે ફરિયાદી પોતે જણાવે જ છે સાહેબ ફરિયાદમાં જ જણાવે છે કે 5000 રૂપિયા મેં આપવાની ના પડે એવું બી કહે છે છેલ્લેથી લગભગ 6ઠ્ઠી લીટી છે જેથી મેં આ રોહિતને રૂપિયા આપવાની ના પાડી અને મારી ઉપર ઉશ્કેરાઈ જઈને સાહેબ
ચાર્જશીટ થઈ છે કે નથી થઈ
બાકી છે સાહેબ
ચાલ ચાર્જશીટ પછી બોલો.
સદરગામમાં અમોની અટક 24/6/2025 રોજ કરવામાં આવેલી છે. સદરગામમાં સાહેબ આપણા અંદર કોર્ટમાં
ચોરી છે ને?
જી સર.
ચોરી છે ને?
જી સર.
ચાલો.
જી સાહેબ. તારીખ 10/9/2025 ના રોજ એસીબી પોલીસ સ્ટેશનમાં પ્રોહિબિશન એક્ટની કલમ 81 ને 83 મુજબનો સાહેબ ગુનો દાખલ થયેલો છે. જેમાં પોલીસ તરફથી આરોપી પરાગ દત્તુ નાફડે, ભૂષણ યાદવ કંદી, રમેશ પુરોહિત અને ભૂષણ પાટીલ આ 4 આરોપીને સાહેબ પકડી લીધેલા છે. તે સિવાય સાહેબ 2 આરોપી વોન્ટેડ છે સાહેબ. હવે અમે અરજદારમાં આમાં હાલમાં સાહેબ કોઈ પણ જગ્યા પર રોલ નથી અને અમો અરજદારને કોઈ પણ નોટિસ આપી નથી અને એફઆઈઆરમાં અમારું ક્યાંય નામ પણ નથી સાહેબ. તેમ છતાં પોલીસ દ્વારા અમોને બોલાવવામાં આવેલ છે ઇન્કવાયરી કરવા માટે સાહેબ. તારીખ 15/9, 17/9, 20/9 આ 3 વખત અમે ગયેલા હતા અને 23/9 પણ બોલાવેલા હતા, પણ સાહેબ ત્યાર પછી અમે આગોતરા જામીન દાખલ કરેલા છે. સાહેબ અમારો કોઈ રોલ ન હોવા છતાં પોલીસ તરફથી અમને બોલાવવામાં આવે છે અને શું બાબતથી બોલાવવામાં આવે છે કોઈ ખુલાસો કરવામાં આવતો નથી. એટલા માટે સાહેબ હાલની આગોતરા જામીન અરજી કરવામાં આવેલી છે. અને સાહેબ અમારો કોઈ ગુનાહિત ઇતિહાસ પણ નથી, જે પોલીસની એફિડેવિટમાં કોલમ નંબર સાહેબ 34 પણ આપવામાં આવે છે. સાહેબ આમાં કોઈ જગ્યાએ ડાયરેક્ટ કે ઇનડાયરેક્ટ કોઈ જગ્યાએ અમે કોઈ વ્યક્તિને
14 લાખનો
13 લાખ
દારૂ છે.
39 લાખનો 13,39,000 નો દારૂ છે.
એટલે 14 લાખનો દારૂ છે
જી સાહેબ.
અને સીસીટીવી ફૂટેજ છે. રેગ્યુલરમાં આમ છે કે ઓર્ડર કરવો છે? ચાલો.
વગર એટલું સાહેબ કરવામાં આવે કે
ભાઈ વોટ ઇઝ આસ્કિંગ યુ?
સાહેબ
બોલો.
સાહેબ એટલું છે કે જો એફઆઈઆરમાં નામ ઇન્વોલ્વ થાય તો અમને ઇન્ટિમેશન ખાલી આપવામાં આવે, જેથી કરીને અમે અમારો બચાવ કરી શકીએ. કેટલા પૂરતી આપે તો બી સાહેબ
અરે ભાઈ યુ કમ રેગ્યુલર.
ઠીક છે વાંધો.
ચાલો ચાલો.
ફેમિલીનો કોન્ટેક્ટ કરીને સાહેબ પૂછી લો.
હા. રેગ્યુલર છે ને?
Serial 25 and 26
એક
we'll see MH Chaudhary.
બીજી એક આમાં કેલ્ક્યુલેશનમાં આગળનું એક રાખી છે કોઈ નંબર રાખી છે. એક બાકીના જે છે 2 ચોરી છે એટલે એનો બધું ચોરીમાં કઈ someone is taking instruction. I am asking કે after investigation is taking the કયો નંબર? હા ચાલો.
Number 25 and 26, sir.
ચાલો.
Still number 1, Bhakti Singh KS Desai, Kishore Chandra Harkishan Das, PI Sri MS Sheikh,
હવે લઈએ એક લાખ જોઈશું. एक inconvenience करता हूँ स्टार्ट तो करिए चलो પછી બેસ્ટ
Question number 224. Topic से पीवी चोट पड़ा देवांग विनुभाई भराला
આપી દઈશ
हाँ जी Question number 5. वकील से एस आर रावल वकील से टी जे शर्मा
હા
ફરી વાત છે સર ખાસ એ છે કે ગર્જન વખતે આપણે જોવું પડે એવું તો સવારે ત્યાં ગયા
એક જ વાત છે there only
मोहम्मद जुनेद असलम कापड़िया इरफान सत्तार मंसूरी एग्जामिनेशन रिपोर्ट मोहम्मद लतीफ मोहम्मद साबिर लीलगार मोइनुद्दीन अमानुद्दीन शेख वकील सी एस टी गोगे पीएसआई सी जे एच राजपूत सर एक वाड़िया साहेब નો મુદ્દત રિપોર્ટ છે 28 નંબરના સાહેબ છે
હા,
મુદ્દત
એક જ
રિપોર્ટ છે
લઈ લો હો બેન ચલો
સીલ નંબર 17 વકીલ સી કે જે શર્મા બોની વિનોદભાઈ શાહ
સર ઠીક है પછી
સીલ નંબર 18 વકીલ સી કે નાખરા हाँ बोलो
સર
સીલ નંબર 19 વકીલ સી બી બીડી મુખર્જી ટ્રાન્સફર થઈને આવી જશે
સર
Serial number 20, वकील श्री GM पाटिल,
वकील जी डी पाटिल,
किशोर नारायण भाई गौड़,
किशोर नारायण भाई गौर,
तन्नू श्रीनाथ मेहली,
धन्नो श्रीनाथ मेरी। हाँ तो
Serial number 21, वकील श्री हाजी पारेख, ट्रांसफर थी ना 20 मीटर
છે આમાં તપાસ્યા છે કે ચાલો બેટાડી
हाँ जी
સિરિયલ નંબર 8 માં સાક્ષી આવેલા છે અરજદાર તરફે એમએસસી
કોઈ વાત ચાલો
Serial number 22, वकील श्री AF गढ़वी, वकील श्री VC लाथिया, वकील श्री VR शुक्ला, वकील श्री SS कटियारे,
वकील जी ए बड़वे, वकील जी वीसी लाडिया, वकील प्रिया दुगला,
रोहित बाबूभाई कापोपरा, रोहित बाबूभाई कापोपरा,
रोहित बाबूभाई काकोद्रा,
31 માં પ્રેઝન્ટ છે, 4 નંબર વીક છે એનો રિપોર્ટ છે.
29
29. Serial number 23, वकील श्री AZ शेख,
वकील जी ए से 70
Serial number 27, वकील श्री PT राणा, वकील श्री YB वाड़ा, બધા સર યુટીપી છે
की बात की बात मैं बात
સર બધા યુટીપી છે કારણ કે આમાં જો ઇફેક્ટ નથી આવી એટલા માટે
70
अच्छा सर.
लो पहला पीआई ने ले
PSI श्री JH राजपूत, वकील श्री SP मिर्जा, वकील श्री KC पानवाला, वकील श्री SD गुगे,
पीएसआई जी ए के राजपुर के जी बिरजा बिल्ली के जी पानवाला के जी गुगे
टीटी वाला बोलो.
હવે ऐसा क्वेश्चन ऑफ income is concerned, there is no because Bishalan was not doing anything at the time of this. Right? એમના જે ડિપેન્ડન્ટ ફાઇલ કર્યા છે તેમાં બે ડિપેન્ડન્ટ કોણ છે ટોટલ એક છે ભાઈ બે ડોટર્સ બીજી બે ડોટર છે તે અંગે ડિપેન્ડન્ટ ડોટ હવે એમાં એમનું એવું કેવું છે કે વન ઓફ ધ ડોટર જે છે તે હસબન્ડ ગુજરી ગયા સેકન્ડ ડોટર જે છે ત્યાં તો મેરેજ થઈ આ સિચ્યુએશન હવે now the question comes as regards ethics. I have already followed my case by office and as per following things has come in from examination. હું આ કામદાર પક્ષમાં સમજ મળેથી જુબાની આપવા આવ્યો છું 13/10/18 ના રોજ હું કરેક્ટલી મોટરસાયકલ નંબર 16 લઈને જતો હતો અકસ્માત વખતે હું મારી મોટરસાયકલ લઈને રસ્તાની ડાબી બાજુએ ધીમેથી ચલાવતો હતો મારું અકસ્માત સાયકલ ચલાવનાર રતનજી સાથે થયું હતું સાયકલ ચલાવનાર રતનજી અકસ્માત સમયે રસ્તા ખોટી સાઈડે આવીને મારી મોટરસાયકલ અકસ્માત અટકાવવા માટે મેં મારી મોટરસાયકલને બ્રેક પણ મારી હતી અકસ્માતમાં મારો કોઈ વાંક So he was driving the vehicle on the left and the correct portion of the road. And at the time of accident, it was the deceased who was driving the vehicle, was moved the vehicle on a portion of road on account of which the accident has taken place. So આને માટે directly Supreme Court નું જે judgment છે કે when one vehicle is flying on left and correct portion of the road and another vehicle comes on total wrong portion of road, then in that case the parties who have deviated the vehicle, those parties are liable to pay the compensation. Now, he has not challenged the affidavit of the right. 51 years of age, depending on Georgia to bear. I have called upon the driver, no occupation group, no income. And the citation said there are people to also rely upon the latest judgment of Honorable Supreme Court, Mandula Bill, and EMA 6% interest, latest judgment 6% interest. So I will inform the applicant. This serial number. ready with my answers. Okay. પછી બીજું જોઈએ એટલે complete થઈ જાય બોલ. Serial number 2 203 215
હમ.
પછી serial number 4 છે 58180. Serial number 10 છે મારો option
સની આમાં શું કરવાનું 2 3 4 માં
applicant evidence મારો નથી.
27 28
The serial number 11 છે ને સર એમાં મારો option કાલે આવવાનો છે આપણો સ્ટેશન છે એ સેટરડે છે એ કાલે આવી જશે.
કાલે ના બોલો
કોઈ પણ સેટરડે આપી દો સેટરડે
18 તારીખ પછી
serial number 14
હા
જે છે 532 અઢારે આર્ગ્યુમેન્ટ કમ્પ્લીટ કરી દીધી છે. serial number 15 માં એક ડેટ લેવું I would take some
તમે 14 માં દલીલ કરી
14 માં દલીલ કરી 15 માં હું એક ડેટ લેવું છું. 17 માં મેં એક એપ્લિકેશન ટેન્ડર કરી છે બોરિંગ ઓફર અને સિરિયલ નંબર 20 માં સેકન્ડ વેહિકલ નું જોઈનર નું અરજી છે જે સાહેબે મંજૂર કરેલી અને એના પર છે. હવે 159 હું I will start my arguments. This is the case in which I am relying upon three aspects of the defense of my case. One is the interest, second is the disability certificate, and the most important thing is the income which is there. Whenever disability certificate is being given, it is very necessary and essential, sir, to significant. When a person is a MS ortho doctor, then there in the case whether he can give any disability certificate pertaining to the bladder, pertaining to the head injury, and pertaining to the speech which is there. This doctor has given disability certificate pertaining to the speech for which there is absolutely no local standing to give because it is only an ENT specialist who can say whether this person has a problem of speaking or not. Secondly, pertaining to that, this person had come before the court for 1 hour and 10 minutes. He was cross-examined by me. Going through all my cross-examination of more than 2 pages, it is absolutely very clear. At that time, it is also possible to see from the camera regarding that he was cross-examined for more than 1 hour, and there was not inch of doubt that he was not able to speak well. Now, in that facts and circumstances, who is the person who can give a disability pertaining whether he is not able to speak properly or whether he is able to speak properly? So it is only the ENT specialist and the test which is being conducted. On that basis, we come to a conclusion that whether this person has a disability or not. Now the bills which are produced before the court, the bills are produced even of year 2030, that is prior to date of death, accident as on 2014. In that, he has sustained injury on his tongue, on his face, and on his jaw. So this issue of injury was much prior to the date of accident. Despite the fact this person has sustained injury twice on his tongue, he was able to give his deposition as well as the cross-examination very properly. So as far as the question of challenging or proving that he is not able to speak well, who can be one of the best person? The judge who was conducting. And he has not made any remarks that he is not able to understand or he is not able to speak properly. If we consider that 25% which is given, under that circumstances, we cannot understand what he speaks. But the fact he spoke very clearly, and that the person was I am not able to say. So this speech, now second comes gallbladder, which was there, that the urine was passing. There is nothing mentioned in any of the documents regarding the issue of the bladder, regarding that the bladder which is there is some problem or the other problem on account of which this problem is sustained and urine is not passing. There is nothing mentioning any of the reports. And for that, what is to be conducted? A test has to be conducted. And if a person has problem which the doctor has, then within 10 minutes, 15 minutes, this person has to go to urine. Now, this person of year 2014, he worked in the same institution as a collection agency in collection department for the 3 years. So if this problem has been sustained, then this person was in no capacity to continue with his work which is there. And there was not inch of any of the issues that this person was not working at. So as well as the question of bladder is concerned also, for 1 hour, he gave the deposition. He could have within 10 minutes told the judge that I want to go to the urine, I'm sustaining this problem. So this issue which was there is also absolutely wrong, which the doctor has given. So as far as the question of speech, as far as question of the bladder, and third is regarding the injury which is there on the head, which is there. Who is the person who can give this, who can sort out this issue? It is only a neurosurgeon who can tell that this is the problem which is sustained, and account of this problem, this issue is taken place. Now, whenever an accident has taken place, the doctor takes the completely details about the disability certificate. There are 5 to 6 criteria which are there. One is on the disability certificate, that must be the certificate number, there must be his signature, there must be his thumb impression, there must be his photographs, and the most important thing, as per the central motor vehicle rules, is the examination report which is there. Now, as far as the question of examination report is there, what is the main issue? The injury which he has sustained at the time of the accident, those has to be compared with the present issue, and the present issue which is states regarding the old problem. The test has to be conducted, and both the tests, after conducting all the tests, at the time of injury, what is the issue? At the time of disability certificate, on the basis of the scientific test, what is the issue? Combined with this oral examination, that has to be taken place in the disability certificate, and that has to be mentioned in the examination report. He did not brought any examination reports, and he stated in for us that he has not seen a single document at that time, or even when he has sustained injury. The documents which are there. So this if any XYZ person tells that I have XYZ problem, and the doctor notes and prepares it, then in that case, how can we rely upon that certificate? A question arises. So the doctor who has given this certificate, that certificate does not inspire any confidence as regards the genetic, because any certificate which the doctor prepares without any scientific test, reports, MRI, X-ray, is the question whether that can be taken into consideration. If we talk about Supreme Court judgment, Rajkumar versus Ajay Kumar judgment, in which a detailed one paragraph is mentioned by the Honorable Supreme Court, that those doctors, the treating doctor or medical board, these are
The court has noted down that
not pata sir.
and I have got
But
that certificate of the permanent partial disability on the part of the doctor certifying is not accurate and correct, and you brought the notice about the fitness and worth of the applicant.
now the doctor states now, so these are the things which have come before the court. The doctor has gone even one step further to what is being there. His duty was just to examine and write. Not even that, the doctor has gone one step further by mentioning 4 things very wrongly in his disability certificate. If we go through page number 2 of the doctor, paragraph number 2, 4 things he has mentioned very wrong. That this person was in coma, which he has mentioned. This person has sustained fits. Person cannot be work of what he was doing as a collector. 4, he cannot drive any vehicle. These 4 things have been mentioned. So now, if a person cannot drive a vehicle, sir, then in that case, whether this person, whether this doctor knows any actual facts, if he knew the actual facts, asking him details, then in that case, it has come on record that from 2015, 14 to 2017, this person was regularly working properly in the institution. So if there could have been any problem, then in that case, the urinary problem is there. The problem of communication with their customer. His duty was a collection, in which what criteria are there, that he has to talk with his lower persons, he has to talk with his client, and he has to go to his client and communicate and do the work. So this doctor is giving the disability certificate, mentioning all the things wrong without knowing any details. Now coma, nothing is there on coma. Now he is telling that he might have sustained fits. So how can he tell before the court that this is not mentioned in the disability certificate? This is his telling orally regarding coma, for which no proof is there. Regarding the fits, so how can he tell fits unless and until he has gone through any documents? He has mentioned fits. So His disability certificate is wrong, is a question. But this doctor has gone one step ahead before the applicant, which has come on record. And all these four things is not able to prove anything because he has no evidence that four things which he has stated orally without going through any of the records, the documents, etc., 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 is true, correct. So in support, these are the things which have come before the court. In support of my case, I could have just argued out my case directly. These are the facts, but I have not stopped giving full stop here. I have gone one step ahead. I have produced before the court opinion report of the doctor, and in the opinion report which was submitted before the court, he has just thrown off the clothes of the doctor by mentioning each and everything, whatever he has done wrong in this case, what are the procedures which has been applied. First thing, eligibility of the doctor. Whether this doctor MS Ortho is eligible for giving certificate as regards the issue of gallbladder, ENT, etc. His eligibility, which is there, he has very clearly mentioned in this that whether this doctor is eligible or not. And secondly, he has also mentioned okay, what doctor should do, what doctor has done, which he should not do. What he has done, which he should not do, and what he should not do, what he has done in this case. That has also come in record. It has also come in record that any certificate given by a doctor without any scientific test cannot prove this case. So the best person who can give this disability certificate is only the ENT specialist as far as the question of speech is concerned, surgeon in case of head is concerned. And one side, the doctor has also mentioned, which has come in cross-examination, that a doctor can stand, that a patient can stand, sit, walk without any support of any person. So here, where is the question that this person has some of the disability? When it is stated that 3 years is working, he can stand, sit, walk, he can also speak properly in the court. So the disability certificate which is there, which is produced before the court, what is the genuineness of the disability certificate? So Rajkumar's judgment is clear, and I will submit the opinion report of the doctor of 3.5 which are also damn clear that this disability certificate can never ever be taken into consideration. Into consideration the government, the examination said non-performing of the procedures which is mentioned in the Central Motor Vehicle Rules Act, and how the disability certificate is given. Now, this doctor is absolutely so smart that what he has told in the cross examination is absolutely quite amazing. He has told that he is an expert person of bones, and he told that a neurosurgeon or ENT cannot give disability certificate pertaining to bones. As far as the question, and further he stated that he cannot give treatment of ENT as well as neurological, but he can give disability certificate as for neurology and ENT. That he is more than Supreme Court. And all the persons who are having more degree, they cannot come in this case of bones. So this is absolutely quite amazing, which he has mentioned in his podcast. He can give all the things, but the other person cannot give. This is also absolutely quite surprising. So such practices of the doctor should be curtailed, and taking into consideration the cross-examination which is there, it does not inspire any confidence as regards genuineness. Now comes the question: the income. The witness has come before the court, and the witness who has come before the court had given evidence on two aspects. First aspect is pertaining to that first he was present till 2017, and thereafter they don't know. And secondly, the person who has come before court stated that he has obtained authority letter, but the authority letter which is there, it does not know which person has signed this authority letter. Further, he stated that I don't know the person who has signed. Further, he stated that he is not from the HR department. He is absolutely from the department, and he has the right to give deposition before the court only in surface cases, not other. So those persons, and I also asked question that you produce this income proof. whether you have tallied what is mentioned over there, whether you have brought his TDS certificate, whether you have brought his NEFT, because as this person is working in AU finance company, all the amount which is being given is giving by way of NEFT. That is the entry of the credit and debit. The applicants could have also been produced before the court, the copy of all the bank details of him regarding the income which he has not produced for the court. Under the facts and circumstances, the person himself tells that he cannot comment on the income of this person because he had received by post the details which is coming before the court, and absolutely he has authority for surfacing this and not the present details. So he has stated two things. The first, that he is earning rupees 9,938 and second amount, and secondly 11,000 was the gross which he was receiving. So this income which was there is also unproved income of that applicant. Right? So under the facts and circumstances, in case of PSS, not more than 20,000, PSS 20,000, loss which he has stated before the court that he had recovered after 4 months. That is 4 months. Medical bills 6,50,000 has been confirmed, and the rest of the bills were disputed bills, and they were those bills. It is 2030. It was for the injury of the job that was prior to the accident, and others 15 to 20,000. And as far as the question of disability is concerned, taking into consideration the prolonged treatment is there, go for I think 7.5% body as a whole. Now I also rely upon the Supreme Court judgment, and in that judgment it is absolutely very clear regarding as far as the question of what amount has to be taken into consideration. The Honorable Supreme Court has taken into consideration 1/4 of the total disability, 1/4, which I am producing before the court. The latest judgment, and which 2.5 paragraph is mentioned. The Honorable Supreme Court has gone to this book. The basis of this book is considered 1/4 of the total disability for 48 was taken. This case, which is there. Although each and every case depends upon its own merits. As far as the question of this case is concerned, I can straight away, or even tell that after 4 months, he was regularly in this and he continued till 2007. And he also stated, the person also stated, this is the judgment which is there. And Rajkumar versus Rajay Kumar is directly straight away applicable.
Okay. Good.
Serial number 40.
हाँ फाइनल अजय नहीं नहीं
साक्षी शेगले साक्षी
हाँ
8
हाँ
8/8 I am for the respond. Waiting for
30
कई तारीख
6 7
6/10
हो गया
ને બોલાવવા માટે બાકી રાખેલું છે ઓડિટ નો ચાલે છે એટલે સાહેબ એક આવતો કે સી બોલવા
28 बोलो हाँ तो अरे जे તમને ક્રોસ કરી ચાલો બીજું કોઈ ચાલો કોઈ જલ્દી પહેલેથી લો 1 નંબર 4 છે 2 4 ઓર્ડર